Okay, we all set?
I think so.
All
All right, I'll
set.
call the meeting. This is the October 6th meeting of the Commission on Governmental Ethics and Election Practices. We're here to, it's kind of a special meeting. We're here to consider a petition for Maine Clean Election Act eligibility from Kenneth, is it Capron or Capron?
Apron, like an apron.
Capron? Very nice. That'll square me away. Thank you. So we're here to consider Mr. Capron's application for Clean Election Act eligibility. Mr. Capron, if you'd introduce yourself to the commissioners, that would be great.
I'm Ken Capron from Portland, Maine, running as a candidate for governor and Republican.
Okay, terrific. The way we ordinarily do these cases is I will ask Mr. Wayne to give us a brief background on the case, and then we'll hear from you. It doesn't appear that there's anybody else who wishes to speak at the meeting. So after we hear from you, we'll close the evidence and we'll consider the case. Mr. Wayne.
Sure. Mr. Capron has been intending to qualify for Maine Clean Election Act funding as a candidate for governor. And in order to do this, he would need to collect 3,200 qualifying contributions between October 15th coming up and April 1st of next year. And he would also have to qualify for the ballot. And presuming he collects those qualifying contributions and turns them in, one of the items that we would have to certify in order to pay him the Maine Clean Election Act funds is that he had complied with the seed money restrictions. In returning for receiving the public campaign funds, there are certain restrictions on contributions and spending that candidates agree to, including these seed money restrictions before they qualify for funds. The staff recently heard about a particular transaction that we expressed to Mr. Capron we thought may not comply with the seed money restrictions. That has to do with a political consultant in Florida who operates under the name Kaplan Strategies. So in the spring, Mr. Capron was interested in receiving services from Doug Kaplan. They came to an agreement of about $5,000 worth of services. And on July 2nd, Mr. Capron paid $2,000 to Kaplan Strategies, which he has described as a personal guarantee. And then later on, he went on to provide another $500 to Kaplan Strategies, which consisted of $500 in seed money. So I should mention that the $2,000 was personal funds that he paid to Mr. Kaplan's firm. And the idea that, as Mr. Capron expressed it to us, was this was a personal guarantee to make sure the vendor knew he would receive payment even if Mr. Capron failed to collect enough seed money to pay for the $5,000 in services. That's why the $2,000 was put up. So Doug Kaplan's firm has been providing services. He conducted a poll for Mr. Capron, established a website for Mr. Capron, and one of the elements of the website is that there's a page now where Mr. Capron can start to receive seed money contributions. And I think he's received a couple so far on the website. But there's a business dispute between Mr. Capron and the vendor about the quality of the website, which I don't want to go into myself, but that's sort of an element in the background of all this. So Mr. Capron was kind enough to be interviewed by us, and as we understand the facts, it seemed to us at the time I wrote my staff memo to you that the $2,000 ought to be viewed as a payment for services. And there were two data points that led me to recommend that point of view to you. One was that I think in the interview when we talked to Mr. Capron, he said there was not an intention for the vendor to have to return the $2,000 to Mr. Capron. I think that was confirmed in the letter that Mr. Capron wrote to us that said, if Doug Kaplan's firm performs the services as agreed to, Mr. Kaplan gets to keep the money. So at the time I wrote the memo, and still now, I have to say this strikes me as the $2,000 payment as a payment for services. And one of the requirements of the seed money restrictions is that all goods and services received during this qualifying period have to be paid for with seed money. And that's the first deviation from the seed money restrictions that I see, that he has used $2,000 of personal funds to pay for the services. In the submission, I'm just going to say one more thing, and then I'll let you deliberate and hear from Mr. Capron. We did receive a submission at 6 p.m. last night that we forwarded first thing this morning, and Mr. Capron is saying that if you'll bear with me.
I did have a chance to read it.
You did?
Mm-hmm.
I did. I don't know if other commissioners
I did as
or
well.
not.
Well, what he's saying is the intention was that he would receive $5,000 worth of services, and those $5,000 worth of services would be paid for with seed money. So that continues to raise a question for me. What is the status of the 2,000? If the vendor is going to keep is the vendor going to return the 2,000? Is the 2,000 a partial payment for services? And I don't know. To the commission staff, this still seems like a violation of the seed money restrictions. Under the statute, however, if a candidate makes a mistake with the seed money restrictions, and if the mistake is unintentional and doesn't constitute a significant infraction, the commission can make the decision to allow the candidate to remain eligible for Maine Clean Election Act funding. So that's one of the things Mr. Capron is, I think he doesn't agree that there was a violation, but in the event that the commission did decide there's a violation, he would very much like to continue being eligible for Maine Clean Election Act funding. So that's a decision before you today. That's all I had to say by way of introduction. Thank you very much.
And it's the case, isn't it, that Mr. Capron checked a couple of times with Ms. Brand about the $2,000, and she told him twice not to do it?
I apologize. I'm getting over a cold. I'm sorry.
I'm sorry.
No, it's me. What Lori Brand told me is that multiple times Mr. Capron asked, can I use my personal funds to pay for something to the effect of, I want to pay this vendor for a website so I can begin to receive seed money. Can I use personal funds to pay this vendor for this website? And she told him no on what she described as multiple occasions. So that's my understanding.
Are there questions for Mr. Wayne from other commissioners?
Not at this time.
No. Commissioner Leclerc.
Just briefly, because it's a public hearing, what is the philosophical basis for the restriction of spending to seed money if someone's intending to qualify for Maine Clean Elections?
Well, one of the objectives of the Maine Clean Election Act program is to diminish the candidates' reliance on traditional campaign contributions. And yet in the design of the program, there's a recognition that at the start of the campaign, candidates need some money just to get started and to pay for beginnings of communications to their constituents and their voters. And also in the case of candidates for governor, there may be expenses associated with collecting the 3,200 qualifying contributions that cost money. So seed money, up until recently, for candidates for governor, they could collect up to $100 from individuals, and that is defined as seed money. And that $100 limit has always applied to the candidate themselves. So the candidate is treated just the same as every other potential contributor. As of a week or two ago, that maximum amount per contributor was increased to $250 per contributor. So now, if I want to help out a candidate for governor, qualify for Maine Clean Election funds, I could give $250 to them. So it's basically like, it's called seed money because it's kind of like startup money, but it's limited. That's the way the law was written.
Thank you.
Yeah.
And how much seed money can a candidate for governor collect?
Up to $200,000.
Okay. Any other questions from commissioners for Mr. Wayne? Okay, Mr. Capron, we'd like to hear from you.
Thank you, and I'm glad you've read the addendum from last evening. It seems to me fairly clear under Title 21A, subsection B of hang on. Oh. Sorry about that. Under Section B of Statute 1125, it does very clearly state that a candidate may obligate an amount greater than the seed money collected, which is exactly what I did, but may only receive that portion of goods and services that has been paid for or will be paid for with seed money. And in this case, the $5,000 is the intent is to have it paid for or will be paid for with seed money as it's collected. That was the intent of the $5,000. The $2,000 was a separate transaction entirely, setting aside money so that Doug Kaplan would know that I'm not just some fly by night, because there's always a high risk in this type of campaign that the candidate would drop out, or that for some reason not receive the contributions necessary to pay $5,000. So we agreed not $2,000 of services, but to set aside a $2,000 amount that would hold that money. So a candidate can commit to future expenses. There is nothing in the regulations, however, about personal guarantees for that future commitment. And it's not unusual in any business environment to guarantee a loan, or in this case, it's almost like a retainer. That's not a donation or contribution. That's a retainer. It's a payment set aside that the lawyer will draw down on as they provide services. The fact is that the essence of the transaction is that over time, as seed money came in, the $5,000 would be paid at about $500 a month. And that at the end of that, the $2,000 would be sitting there in Doug's hands to use for additional services. There are several places in the various dialogues we've had, of which you've gotten copies. There are a lot of services that they wanted to offer, but they're all going to be extra. So that $2,000 would have then gone to pay for those future services. The only present services were a poll, which they reluctantly did. They didn't think that was included in the 5,000. And then this website, which we've been dealing with now since beginning of July. And the question is it even a billable service at this point that they provided a website, because it's not working the way it should. It has, we don't even know, I don't even know that payments are being processed properly by the website, because only 2 payments in all this time have come through that website. So and Kaplan has had to change programmer, and we're working on trying to figure out how that's going to be funded, because the new programmer is going to want to start all over, and I'm not excited about that. So as a result of putting the $2,000 aside, that's a hedge against what some future expenses, specifically the ownership of the domain, the WordPress contract for hosting, the copyright for coding, and the pay portal. Those are all things I don't have access right now to the website to take ownership of it. And I may end up having to, if I continue, I'm going to have to figure out how to afford to buy that from them now that they have set up the domain and the basic coding. But if you notice, if you visit the website, you'll notice several places that are blank, incomplete, or in process. And I have no way to judge how many visitors come to the site. I have no statistics. In other words, it's not very functional at this point. And I may have to take Doug to small claims court to get my $2,000 back. But that's there's nothing guaranteed about that legal process, but that's what has been suggested by a lawyer, my lawyer. So I felt comfortable that the personal guarantee aspect was a normal business transaction. No services were provided as a result of the $2,000. The services provided, I paid $500 towards that in the interim, and that came out of $644 of total contributions at that time. So the funds that had been paid for services rendered, the $500, did come out of seed money. So I'm a little bit at odds with the interpretation of personal guarantee. I don't think it's supported by statute nor rule. No one can certainly say what will happen to the $2,000. Ideally, the seed funds would cover the remainder of the oral contract, the $5,000, along with seed funds collected. But the obligation is out there, and the regulations are not very clear on what happens if you make an obligation and then can't pay it. Which is exactly the reason why Kaplan wanted some sort of upfront payment that would hold the funds in case there is a shortage. And right now, I mean, obviously there's a substantial shortage on the $5,000 contract. Contract is intended to go all the way to next June. So $5,000 spread over a year and a few months would certainly not indicate that we've spent $2,000 worth of services or that we've conducted or accepted $2,000 worth of services. There's a long ways to go in what they guaranteed. So I don't see a statutory definition of personal guarantee. I don't see any exclusion on that. As lawyers, you folks know what a retainer is all about. This is no different in many ways from a retainer. But again, the statute doesn't deal with that. I will add one thing that Jonathan mentioned, and I'm glad he did. That technically on day one, a candidate in this category has $100 to do everything from scratch. That's it. There's $100 seed money that the person can make up front, and then they have to go out and start collecting seed money. And one of the steps in collecting that seed money is a working website, setting up a bank account, acquiring literature, printed materials, and so on. So I mean, I don't know how reasonable it is to expect a candidate to survive on their initial $100 contribution. But I know that the other candidate in this race who's on Clean Elections has had the same comment. I'll leave it there. I believe I complied with Section B about obligating an amount greater than the seed money collected, but may only receive that portion of goods and services that has been paid for or will be paid for with seed money. That's very clear.
Thank you, Mr. Capron.
You're welcome.
Thank you very much. We appreciate your hearing from you. I have a couple of quick questions.
Yes.
It's true, right, that you wrote a $2,000 check from your personal account to the Kaplan firm?
Actually, that was the discussion that we had with Kaplan, but Kaplan wanted something more sooner than writing a check and what have you, because I would have had to have gone and get checks and stuff, because it was a new bank account. I did not have checks available. So their method of accepting a transfer or payment would have been through their accounting system, which generated, excuse me, an invoice with a clickable link to their bank account. So I was able to
So
make
it was in effect, it was a wire transfer?
In effect, yes.
Okay, great. Thank you. Any other questions from commissioners for Mr. Capron? Yes, Commissioner Hastings.
Just one question, Mr. Capron. You in your presentation described this as a retainer against which services will be billed when provided. Do you have anything in writing from Mr. Kaplan, any sort of an agreement with him that identifies this as a retainer, which you could have returned to you at any time? If no services were given?
We did not have that discussion, no.
So you characterize it as a retainer, but he may not have.
I don't know that I could agree with that. I think that the discussions that we had, which I think I gave you folks copies of a lot of the back and forth on what services were to be provided. It was referred to them by a down payment, as a down payment in their emails and contact information.
Are there other questions from the commissioners for Mr. Capron? Yes, Commissioner Leclerc.
Good morning, Mr. Capron. You mentioned that you transferred the funds, the $2,000 over your computer, I assume, by a clickable
link
on Mr. Kaplan's website. Is that correct? Or
they use an invoicing mechanism that to transfer money. They don't put a link on their website.
okay, so the $2,000 that you sent through that link, was that from a credit card or was it from a bank account? And was it what type of a bank account, if so?
It was from my personal bank account.
Okay, thank you very much.
It was half of my life savings.
Are there other questions from commissioners? Commissioner Marble.
I just want to share an observation with Mr. Kaplan. As someone who ran unsuccessfully through Maine Clean Election.
This is Mr.
Excuse me,
Capron.
Mr. Capron, I'm sorry. I just want to clarify your comment about the $100 limit. That is accurate in terms of you yourself considering a seed money donation to your campaign. But back when I ran for the state Senate, I could collect up to $2,000 in seed money out of the gate in no more than $100 increments. So there was a modest way to be able to start a campaign with seed money, and I think that was part of the intent.
And if I could expand a little bit on that, running for a House or Senate is a lot less expensive
Yes.
endeavor. Running for a governor, when your competitors, the other candidates are sitting there with $300,000 they've gotten in donations of $2,000 plus, it really is a deficit that personally I don't think the act was intended. The Maine Clean Election Act, I don't think it was intended to create a roadblock for candidates who had less money than the average candidate. I mean, all but one other candidate in this race has substantial amounts of money that were donated either from personal resources or otherwise. I think the restriction, if it had been in the law, I would have considered this a donation of $2,000 and spent it on things that I needed to spend it on. I did not spend this money on things. There are still a lot of things I need to buy, but $100 doesn't get you any of those. And it doesn't get you anywhere. It's fine for a House or Senate candidate, but for a governor candidate, you need to give them access to using whatever funds are available until they can afford to get the QCs collected.
Noted.
So thank you for your comment. I appreciate where unsuccessful candidates end up.
Are there other questions from commissioners? Okay, thank you, Mr. Capron. To start off the discussion, I'll make a motion. I move that Mr. Capron intentionally violated the seed money restrictions in 21A M.R.S. Section 1125, paragraph 2A, and is therefore ineligible for Maine Clean Election Act funding in this campaign. Is there a second?
Second.
Okay, it's been moved and seconded. Now it's time for discussion amongst commissioners, and I'll start it off. Mr. Capron, I really think that you clearly transferred your own money to a vendor. It was a contribution to your campaign. You can call it a personal guarantee. You can call it Swiss cheese. It doesn't matter what you call it, but the end result is that it was a contribution to your campaign, and that is contrary to the whole philosophy of the Maine Clean Election Act. And there's no entitlement to Clean Election Act funding to having taxpayers pay for your campaign unless you follow the rules assiduously. And so that's why I'm going to vote in favor of this motion. Are there other comments from commissioners?
No.
Okay, hearing none, I'll call for a vote. Commissioner Leclerc?
Yes.
Commissioner Marble?
Yes.
Commissioner Hastings?
Yes.
And I'll also vote yes. Thank you all for coming. Thank you, Mr. Capron, for presenting your case. I'm sorry that it couldn't turn out in your favor.
Thank you.
Yes, Commissioner Leclerc.
A brief question. Is there, and I'm just confused. Is there a separate request for waiver here that we have to deal with, or is that?
This was the request for
This
waiver.
was the request for waiver. Okay.
Yeah.
All right. All right.
Is there another motion?
No.
Maybe a motion to adjourn?
Move to adjourn.
Okay. Yeah. Seconded.
It's been moved and seconded that we adjourn. We'll hold a roll call vote. Commissioner Leclerc?
Yes.
Commissioner Marble?
Yes.
Commissioner Hastings?
Yes.
And I'll also vote yes. So thank you all very much for coming. I'm glad we could get this kind of emergency meeting organized to get Mr. Capron an answer quickly. And I really appreciate everyone's cooperation. And have a great day.
Do.
Can I ask just a procedure? Are we set for December 3rd? Is that now?
I believe we are.
We are.